Judges, like all people, have biases. A judge might unconsciously believe that a working parent is less involved in their child's life. So provide an explanation of how your role actually makes an impact on the child in spite of your employment, and maybe your employment is even a benefit in some situations. And if you know that there's a potential weakness in your case, address it head on. Provide that evidence that counters the negative assumptions that a judge might have about you. Welcome to the HKK YouTube channel. In this video, I will reveal 5 secrets that can help you influence a child custody judge's decision in your favor. These are not tricks or shortcuts, but proven strategies that can shape how your case is presented and how the judge perceives your arguments. Whether you're going through a custody battle or preparing for a hearing, these tips will help ensure that your case is presented as effectively as possible. Secret number 1 is understand judicial bias. The first thing you need to know is that judges, like all people, have biases. And while most people strive to be fair and impartial, their personal experiences and subconscious beliefs can impact how they perceive your case. We call this implicit bias. Implicit biases are these unconscious beliefs or attitudes that can influence a judge's perception and their ruling, even without the judge realizing it. Judges, just like you and me, have personal backgrounds that shape their decision making. So the question becomes, what can you do about it? You must ensure that your judge makes decisions deliberately and not based on these snap judgments. Use facts to override the assumptions. For example, if you're a stay-at-home parent seeking primary placement and your judge happens to be a working parent, which all of them are, they may instinctively view your role differently, right? So instead of just stating that you stay home, provide context. Explain how your daily involvement benefits your child's academic performance, the child's emotional health, and stability. Show the judge why your presence makes a tangible difference in your child's life. A judge might unconsciously believe that a working parent is less involved in their child's life. So provide an explanation of how your role actually makes an impact on the child in spite of your employment, and maybe your employment is even a benefit in some situations. Other areas of potential biases include daily routine, things like school drop-offs, meal preparation, homework help, and doctor visits. The goal is to take the judge from this intuitive, knee-jerk decision-making to intentional, thoughtful decision-making. Here's how to apply this. Address the potential biases directly by framing your arguments in a way that forces intentional reasoning. Provide clear evidence that challenges these stereotypes or assumptions, and focus on the best interests of the child, and use narratives that highlight how your role as a parent supports the child's well-being. Secret number 2 is be aware of confirmation bias. Judges, like all of us, have a tendency to seek out information that supports their existing beliefs. This is called confirmation bias. And if a judge already has an impression of you, positive or negative, everything they hear afterwards may be filtered through that belief. So how do we counteract this? We do it by controlling the narrative from the start. First impressions matter. Dress up to court. Be friendly. Shape the narrative early about your case. Make sure that everything you present, whether it's documents, testimony, or character witnesses, tells the same consistent story, that it aligns with your position. And if you know that there's a potential weakness in your case, address it head on. Provide that evidence that counters the negative assumptions that a judge might have about you. You want the judge to see the reality of your situation and not just their initial perception of it. So for instance, if a judge subconsciously believes that fathers are less involved in child rearing, they might unconsciously give more weight to evidence that supports that belief and dismiss the evidence that contradicts it. So there are ways that you can counteract this. Anticipate the biases early on and provide the evidence that contradicts what the judge might think. The use of narratives and factual context that force the judge to reconsider their assumptions is something that has to be done. Present your evidence in a way that makes it difficult for the judge to ignore, such as using third-party witnesses. Bring them in. Use documents. Use demonstrative evidence. These documents can include parenting schedules, things that show consistency or positive co-parenting efforts. That gets us to secret number 3, the use of demonstrative evidence. Words alone are not enough. And to really make an impact, you need to use demonstrative evidence. So what does that mean? Well, this means anything visual that helps illustrate your argument and keeps the judge focused on facts rather than the personal biases the judge might have. The use of demonstrative evidence is the basic rule of showing and not just telling. So for example, if the other parent claims that they always pick up the child on time, but you actually have text messages showing late arrivals, print them out, bring them to court. Use a calendar to highlight patterns. If you're discussing your involvement in your child's schooling, show attendance records from parent-teacher conferences. Bring in pictures showing your involvement in school activities. Now, judges are more likely to focus on objective facts when you provide them in a clear and visual way. It forces the judges to engage with deliberate thinking rather than relying on their gut reactions. Remember, a judge is constantly bombarded with verbal arguments and written submissions. So one way to make your case stand out is by using this demonstrative evidence, which engages their attention and encourages deeper analysis. Consider using the following items in your case. Things like visual aids, PowerPoint slides, charts, graphs, videos, could be recordings. Bring in maps highlighting distant challenges for parenting time if that's an issue. Text messages or emails are helpful. That helps to show or illustrate communication between parents. School records and photographs are important. Studies show that people retain more information when they both see it and hear it, which makes visual aids incredibly effective in influencing a judge's decision. Secret number 4 is to frame your argument with context. What do we mean by that? Well, judges make their decisions based on what they believe is in the child's best interest. And that means you need to provide context that makes it clear why your position is the best choice for your child. Simply stating, I should have custody or I just want equal shared placement won't work. You need to back it up with concrete reasons. And you want to provide meaningful context to your position. So for instance, if you're requesting more parenting time, don't just say I want 50-50 custody. Instead, explain how your work schedule allows you to be there for school drop-offs and pickups, how you can be there in the morning or after school. Show how you've been involved in homework, extracurriculars, and doctor's appointments. Judges want to see a well-rounded picture that makes your argument undeniable. You'll want to go through the factors in the Wisconsin statutes to understand what a judge considers. The more context you provide, the harder it is for the judge to default to assumptions. Give them concrete facts. Show them things. Judges have limited time and they must process the complex information quickly. So do it at a high level. And if your case is just too difficult to follow, or if your arguments are scattered, then you truly do risk losing the judge's attention. Make it simple. Organize your case with clarity. Have a well-structured argument that follows a logical flow. Chronological is a good way to do it. Summarize the key points succinctly. Judges appreciate when attorneys and the parties get straight to the facts. The 5th secret is to demonstrate stability and co-parenting ability. Judges love stability. Family courts don't just look at what's best for you, they look at what's best for your child, right? This is not about the parents. So show that your choices are best for your child. Frame your case around the judge's perspective. Judges don't expect perfection, but they do expect practical solutions that are in the child's best interest. Many litigants focus solely on what they want instead of presenting a case in a way that aligns with the judge's decision-making criteria. So here are some of the things that judges consider. In consistency and stability, they want to minimize the disruption of the child's life. They want you to show how you can maintain and improve upon that for the child. They want to know that you're doing things in the best interest of the child, focusing on factors like school and medical care, emotional well-being. They want to see parental cooperation, looking for parents who can co-parent effectively. A mistake that parents often make is bad-mouthing the other parent in front of the court. If there's no reason for it, that can backfire because judges often view it as an inability to co-parent. Instead, you want to show that you're solution-oriented. And if the other parent is difficult, then you want to document your efforts to that show that you calmly and effectively cooperate. Keep your emotions in check and always present yourself as a more stable, responsible parent. Show positive communication with text messages, email records that provide examples of joint decision-making and respectful dialogue. And present solutions, not just complaints. Instead of focusing on why the other parent is unfit, show your proposed custody arrangement, your placement schedule, your plan to the judge, and show how it benefits your child. And demonstrate your ability to co-parent. Even if the other parent is difficult, highlight the efforts you've made to communicate and collaborate. So those are the 5 secrets, guys, and to recap, here they are again. Number 1 is understand judicial bias and take the judge from an instinctive to an intentional decision-making. Number 2 is be aware of confirmation bias and shape the narrative early on. 3, demonstrate evidence to keep the judge focused on objective facts. 4 is frame your argument with meaningful context. And 5, show the judge that you're making decisions that are in the best interest of the child. Guys, if you like this video, you could do us a favor and subscribe to our channel. Like it, leave some comments below. We'd love to hear from you and make more videos for you, and we will see you next time. Thank you.